Hello everyone. Today we will discuss last topic of this chapter, that is basic documents of the company. Now in our previous session we have learned something about the documents which a company needs to file while getting registration or certificate of commencement or incorporation certificate from registrar of companies. So today we will discuss in detail what are those documents. Now first document that we are going to discuss is memorandum of association. It is the most important basic legal document. It is a legal document of the company. It is a charter of the company which defines its objectives and determines the boundary line within which company has to work. It can be said to be the foundation stone upon which the future structure of the company will stand. Memorandum of Association establishes the relationship of the company with the outside world. Now let us see the actual definition of Memorandum of Association. According to Section 2, Subsection 28 of the Companies Act 1956, memorandum means the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous company's law or of his act. Means it is not rigid. Memorandum of association is not rigid. All those rules or disciplines which are mentioned in memorandum of association can be changed from time to time. Then let us see some definitions given by some personnel. First, Lord Keynes. He defines the memorandum of association of a company is its charter and defines the limitations of powers of the company established under the act. Means in memorandum of association all the powers of company will be mentioned. Means what kind of work or activities it can undertake. The memorandum contains the fundamental conditions upon which alone the company is allowed to be incorporated. And according to Lord Macmillan, the Memorandum of Association sets out the constitution of company. Just like in India we have constitution, and company also, all of them, they have their own constitution, and that is nothing but Memorandum of Association. In that all the rules and legal laws related with the functioning of a company is mentioned. It is, so to speak, the charter of the company and provides the foundation on which the structure of the company is built. Now there are some things mentioned in memorandum of association. These are nothing but name clause, place, domicile or situation clause, object clause, liability clause, capital clause, association clause. Now let us discuss those things in detail. The first clause that is mentioned in memorandum of association is name clause. It means the name of the company will be mentioned. Now before choosing a particular name for the companies, they have to take into consideration, means they have to think about certain points. Now what are those points? The name should not be identical to or closely resembling an existing company. Means if you are choosing the name of a company, it should not be duplicate or copy of another company, or it should not be same or somehow similar with the existing company. The name should not indicate the company is patronized by the government. Means it should not mention that whether the company is managed or unmanaged by the government. Then the name should not include the word cooperative. We saw cooperative society, so a company and cooperative societies are different, so a company cannot put up cooperative in its name. The name of the company should be prominently affixed outside the premises of the company. Means outside the office of a company, the name should be properly fixed. Means a boarding or some hoarding should be there. The name must be engraved on common seal. Common seal, as we can say in another word, that signature of the company. So the name of that company should be in common seal. Then next clause or next topic that is mentioned in memorandum of association is place, domicile or situation clause. Under this clause, the name of the state in which the company is situated is mentioned. The registered office is the place where all statutory books and documents of the company are kept. This address is used for correspondence from registrar of companies. Now a company can be situated in various places. Like we have let's say example of Geo company. In India they have lots of offices spread all over the country, isn't it? So each state or each city will have each office. So it is important to mention which office is the main office of the company. Means the registered office or the main office, it is the place where all the statutory, all the important documents or books are kept in that office, and that office will receive all the documents or all the correspondence things of registrar of companies will be handled from that registered office. Now, object clause. Under this clause, the main objects and other objects which the company may pursue are mentioned. Means all the primary objectives of a company, means what they are trying to achieve through the business of their company, as well as all the secondary objectives will be mentioned under this clause. The object must be legal, means it should not be an illegal one, and should not be again any public interest and policy, means it should not harm any public or human being. This clause must be clear in precise term because it defines the power and activities of the company. The company must be very careful and cautious while drafting this clause. Means while mentioning the objectives of a company, the terms or the objectives should be clear ones. It should not be confusing one, or it should not be in such terms that it is impossible for anyone to understand properly. That is why while drafting this clause, means while writing this objective clause, it is very important to take necessary cautions. Then next is liability clause. It must be clearly stated in the memorandum of association that the liability of the shareholder is limited to the nominal value of share held by him. If the liability is limited by guarantee, it should be clearly specified. Means if the shareholders or directors of the company's liability is limited till the nominal value, that is means till the amount of the shares held by him in the company, then it should be mentioned in liability clause. If the liability is limited by guarantee, means if the shareholder is guaranteeing up to a certain amount of money, then it should be clearly mentioned under this liability clause. The next is capital clause. Under this clause, the authorized capital of the company is mentioned. The types, numbers and denominations of shares should also be mentioned. Means under capital clause, the total capital amount of company should be mentioned, as well as authorized capital. The types, there are different types of capital in a company there, so all those things should be mentioned in memorandum of association. Means how many shares they have, and for at what amount each share goes, like it can be rupees 10 per share, rupees 100 per share, it depends upon company. So all those denomination of shares should also be mentioned under capital clause. Then next is association clause. The association clause reads, we the several persons whose names and address are submitted are desirous of being formed into a company in accordance with the memorandum of association, and we undertake to take the number of shares in the capital of the company mentioned opposite our respective names. Means this whole thing will be mentioned under association clause, and under that all the shareholders, they will sign individually. In case of public company, this declaration must be signed by at least 7 persons, and in case of private company, it must be signed by at least 2 persons. Sorry, means not all the shareholders, but in case of public company, since we know that number of shareholders can be unlimited, so in case of public company, at least 7 people should sign this association clause, and in case of private company, only 2 persons can sign. Now this is a pro forma of memorandum of association. Means name clause, place clause, then object clause, then this is also a part of object clause. Means ancillary objective means secondary objectives, then liability clause, then capital clause, and at last association clause here. Now next important document is articles of association. Articles of association of the company deals with the administration of internal affairs. Now memorandum of association, it has all the information which an outsider can inquire about, but articles of association, it deals mainly with the administration or rules of internal affairs of the company, which cannot be 100% or which cannot be fully disclosed to the general public. Now it defines duties, rights, and powers of the management and board of directors. The articles of association of the company must be printed, divided into paragraphs, and numbered. The signatories to the memorandum must sign it in the presence of witness, means those who have signed the declaration clause or association clause of memorandum of association. Those should also sign articles of association, but in presence of some witness. Generally, companies have their own articles, but they may adopt the model articles given in Table A of Companies Act. Means any company they can create their own article, but there is a proper format given in Companies Act, or the company they can adopt that Table A of Companies Act. Now, what are the contents of articles of association? Now, articles of association, it has the amount of share capital and different classes of shares. There are different classes of shares like equity shares, preference shares, then debentures and all those things should be mentioned in articles of association along with the amount of those share capital. Then right of each class of shareholders, means which kind of shareholders have which rights, all those things should also be mentioned. Then details of contracts made with different persons, means if the company has made any contracts with outsiders, then it should be mentioned. Then procedure for making allotment of shares, means how the company they are going to allot the shares. Then procedure for issuing share certificate. Share certificate means each shareholders they will get a share certificate. Now what will be the procedure for issuing such kind of certificate, that also mentioned in articles of association. Then if any shareholders wants to transfer his shares to someone else, then what will be the procedure for him to follow, that also will be mentioned. Then procedure for forfeiture and reissue of forfeited share, means sometimes after issuing shares, when the shareholders they cannot pay the actual amount of shares, then the company they used to cancel those shares. Now that process is known as forfeiture, and after cancelling, the company they have right to reissue again those cancelled shares, and that is known as reissue of forfeited shares. Now if a company has to forfeit the shares and if they want to reissue those shares, then what will be the procedure it need to follow? Then procedure for conducting meeting. Then procedure for appointment, removal and remuneration of directors and their power and duties. Procedure for declaration and payment of dividend, means before giving out dividend on shares, a company has to make declaration for that. So for making that declaration, means how much amount of dividends they are going to pay to the shareholders, all those things should be mentioned in articles of association. Then matters relating to keeping of statutory books, means all the important books, how they are, what kind of books they are going to keep and where they are supposed to keep, all those things will be mentioned. Then procedure regarding alteration of share capital, means with the share capital which a company was initially started, if they want to increase or decrease that share capital also, that also they have to mention the procedure, means if they want to change the amount of share capital. Then procedure regarding winding up of the company, and if they want to wind up the company or shut down the company, then procedure regarding that also is mentioned in the articles of association. Now change in articles of association can be made by special resolution. Any information or any contents, if a company wants to change in their articles of association, then they have to take special resolution. The change must be compulsorily intimated to the registrar of companies, means after they have taken special resolution. Special resolution is nothing but they will hold a meeting, and in that meeting all the board of directors or shareholders they will take resolution, means they will take decision regarding change in the articles of association, and if everyone gives their consent, then that decision will be taken, and that is known as special resolution. Now after taking the special resolution, after changing their articles of association, they have to inform registrar of companies. The articles of association is always dependent to the memorandum of association. Remember that articles is dependent on memorandum of association. If there is any clash between provisions of memorandum and articles of association, the provisions of memorandum of association will hold good. Means if any clause of article association is opposite to article to memorandum of association's clause or content, then at last memorandum of association's information will be regarded as a correct one. Now there are some difference between MOA and AOA. Let us see. Compulsion. The preparation and filing of memorandum of association is compulsory, but articles of association, it is not that much compulsory, because like if they cannot prepare their own articles of association, then they can take help of table A of the Companies Act. Then change. In changing anything in memorandum of association is not that easy, but articles of association, by taking special resolution of shareholders, they can change articles of association. Then 3, contents. It contains the objectives and powers of company, while articles of association, they contain rules and bylaws for internal administration. Then relationship. It establishes a relationship of the company with outside world, because memorandum of association, it gives information of the company to the outside world, while articles of association, it controls the relationship between officers and shareholders of the company. Means generally all the contents of articles of association, it is related with officers and shareholders of the company. It has nothing to do much with the outsiders. Then supremacy. It is not governed by the articles of association, it is supreme. Means memorandum of association is little bit higher than articles of association, because all the rules of articles of association should comply with memorandum of association. Then importance. Memorandum of association is basic and it is very important, while articles of association, it is considered as a subsidiary document. Then dependent. It is dependent upon the common law. Means memorandum of association, it depends on company law, while articles of association, it depends on memorandum of association. Now the third important document is prospectus. Now according to section 2 subsection 36 of Indian Companies Act 1956, prospectus means document described or issued as prospectus and includes any notice, circular, advertisement, or other documents inviting offers from the public for the subscription or purchase of any shares or debentures of a body corporate. Means prospectus is mainly related with the subscription or purchase of shares or debentures of the company. Now prospectus, it is considered as an invitation or offer. Means through issuing prospectus, a company is giving invitation or it is offering to the general public whether they want to subscribe or they want to purchase shares of the company. It contains all material information required regarding financial aspects of the company and helps people in making decisions whether they should subscribe for shares of the company or not. Means it will give only those information which will help general public to understand or to analyze the working of the company and whether they should be subscribing to the shares of that particular company. The company depicts the picture of its golden future through prospectus and motivates the prospective shareholders to subscribe for the shares and debentures of the company. Filing of prospectus is must by the public company. Since we know that public company only they are allowed to issue shares, it is very important for public company to file prospectus before obtaining the certificate to commence business. Before getting certificate to commence, they have to file their prospectus with the registrar of companies. A copy of the prospectus must be supplied with every application form, because we saw that while applying for certificate of commencement or incorporation certificate, they have to apply through various application forms. So a copy of their prospectus should also be submitted through application form. It is not necessary for every company to file prospectus. Means private companies, since they are not allowed to invite subscription from general public, they don't have to file prospectus. Now, what are the importance or what is the purpose of this prospectus? Prospectus contains a printed summary of the company's past history, means all the information regarding company's past history, or if any present status is available, then it should be mentioned, and its future prospect, what it wishes to accomplish in future, all those things will be mentioned in the prospectus. Then it informs the public about the company and stimulates people to make an investment in the company. Now they want to lure the people to take part in their shares of the company, so through prospectus they try to advertise about their own company, that their company is very good, and people, they can obviously they will earn some money through dividend by subscribing to the shares of the company. Then it is an authentic record of terms and conditions on which the shares and debentures have been issued, means all those past issue of shares, all those things will be mentioned in the prospectus. It shows business policies, means all the business policies will be mentioned, and programs also it will be mentioned. If the company is running any social development programs or any other kinds of programs, then it will also be mentioned in the prospectus. These all things are given in prospectus just to show good side or good face of the company. Then requisites of a correct prospectus, means what a correct prospectus should contain. It must not be exaggerated. Exaggerated means something which is not there, means all those correct information should be mentioned and nothing more should be given in the prospectus. Then it must contain a full and honest disclosure, means all the things related with the capital of the company, and those things should be mentioned, and those things should be honest information. Material facts must be disclosed, not concealed, means nothing should be hidden out from the public. There must not be false details and untrue statements. Then what are the contents of prospectus? Let us see. Matters discussed in memorandum of association like name, addresses, and qualification, shares of members signing on the memorandum should be mentioned. Then main objective of the company, assets of the company and share of shareholders in the profit of company, number of qualification shares to be taken by the directors, means if some shareholders want to become director of the company, then how many qualification share he has to subscribe, all those things should be mentioned. Then distribution of the share capital of the company, means how the share capital of the company should be mentioned, like types of shares, number and denomination, as we have discussed in articles of association. All those things should be mentioned in the prospectus as well. Then if redeemable preference share, means this preference share is one kind of share which is refundable after certain period of time. Those are nothing but redeemable preference shares. Now if a company has issued redeemable preference shares, then how many preference shares have been issued, then what are the method and date, and when the payment has to be made by the shareholders to the company should be mentioned. Then name, addresses, profession and remuneration of directors and managers of the company should be mentioned. Minimum subscribed capital of the company should be mentioned. Amount payable on application and allotment. While applying for shares, the general public, they have to pay certain amount of money, so how much they are supposed to pay, all those things should be mentioned in the application. While allotment also, they have to pay certain amount of money, then how much should be that amount. Then date and time of receiving application money, like last date should be mentioned till which a person can apply for shares. Name and amount of shares and debentures issued for consideration other than cash. Sometimes a company issues shares not for raising cash but for something else, and that like machinery or something, land and all, property or assets should be that one, and that is known as consideration. Then name and addresses of underwriters, preliminary expenses and its estimated amount. amount payable to promoters, name and address of auditors, details, and these things are not that much important, but you have to understand the meaning of these things. Means you go through once and there are 24 points, but you can, from your examination point of view, you can by heart 10 or 12 contents. Now, since prospectus is a very important document for the company to issue shares as well as raise capital. Now, sometimes the company, what they do is that to lure more people to subscribe to their share, they sometimes give misleading or misstatement about their company. So there are certain punishment or there are some punishment which they have to face if they had made any misstatement in the prospectus. The persons responsible for preparing false and misleading prospectus will face the civil and criminal liability. Now, there are two kinds of liability. First one is civil liability. In case misleading prospectus amounts to misrepresentation, the aggrieved person, means the person who has suffered any kind of loss because of that misleading or misrepresentation, he can repudiate, means cancel the contract and claim refund of their money. Means if they had already paid some amount of money, then they can claim that amount of money, and company, what they have to do is that they have to repay back. Plus, if there is any other damages that aggrieved party had suffered, then for that also they can claim from the person. If the person is found guilty, then he have to compensate that amount of damage. Then next is criminal liability. In case of any deliberate concealment, means if intentionally anyone had concealed, means hidden something, then the directors will be punished with a fine of 5,000 or imprisonment up to 2 years, or both. Means either he will be charged with 5,000 of fine, or he will get 2 years of punishment of imprisonment, or both. If it is proved to be fraud, the fine will extend to 10,000 or 5 years of imprisonment, or both. Now, first he will have to give punishment fine of 5,000 with 2 years of imprisonment, or both. But if it is after investigation, if it is proved that it was fraud from the director's side, then he will have to pay 10,000 or he will get 5 years of imprisonment. Now, in certain topics we have learned that we have came across statement in lieu of prospectus. Now let us see what is this. A public company may not issue prospectus. In such a situation, it will have to file a statement in lieu of prospectus with the registrar of companies. If a public company doesn't want to issue prospectus, then what that company will do is that they will prepare a statement, and that statement is known as in lieu of prospectus. Now that statement they have to submit it to the registrar of companies. The pro forma of the statement is given below. Means there is one format of statement is given in the third schedule of the Companies Act. Now that this statement, a company has to file it 3 days before allotment. Before allotting the shares, a company has to file this statement in lieu of prospectus 3 days before. Like prospectus, it should also be true and not conceal material facts. It must be signed with the date by all the directors. Now, when this statement is used, if the private company is changed into public company, when a private company is changed into public company, obviously they can invite public to subscribe their shares. In that case, since earlier a private company, they didn't had made any prospectus, now after changing into public company, they can prepare this statement in lieu of prospectus. Now if there is automatic and immediate collection of capital at the time of incorporation, in that case also they can prepare this statement. If the company has not issued prospectus due to any reason, means while calling from general public for subscribing into their shares, if they haven't issued any prospectus, in that case before allotting they have to make this statement in lieu of prospectus. Then if the company has decided that it will not issue shares or debentures to public, means if a company, they from themselves only, if they don't want to issue shares or debentures, then what they have to do is that they don't need to prepare prospectus, but they have to submit the statement of leave in prospectus with the registrar of companies. Now, for starting a business, what basic things that you have to keep in mind? Let us discuss that one. But first, let us see. According to W.O. Wheeler, business unit is a concerned company or enterprise which buys and sells. Now, business, it can be anything, a company or enterprise whose basic function is to buy and sell, is owned by one person or group of persons, and is managed under a specific set of operating policies. Now, according to W.O. Wheeler, business is nothing but it can be a company or enterprise whose main function is to buy and sell. It can be owned by one person or several person, and which is operated under certain specific policies. Now, business enterprises are concerned directly or indirectly with the production, purchase, sale, transfer, and exchange of goods and services on regular basis with profit motive. As we saw in business, the main functions are nothing but production, purchase, sale, transfer, and exchange of goods. Now, with profit motive as obvious. Now, let us see some characteristics of business organization. Now, it should be an economic activity. It must be concerned with production, purchase, sale, transfer, and exchange of goods and services. Without these functions, we cannot say that it is a business organization. Then we know that business should have profit motive. There must be a regularity in business dealings, and business activities are nothing but it is done to satisfy human needs. Now, how are you going to choose what kind of business organization that you want to choose? Either you want to choose sole proprietorship, partnership, company, cooperative society. Lots of options are there. So to choose a particular form of business organization, you should consider these points. Now, according to Professor Haney, while selecting the form of business organization, the following factors must be taken into consideration. You have to understand these factors before selecting any type of business organization. First point is easy formation. Sole trade is the best form of business organization from easy formation point of view. If business is to be carried on large scale, company form of business organization is good in spite of the difficulties in its formation. If you want to start your business easily, then sole proprietorship is good for you. But if you want to start a big business, then company form of business is suitable for you. Now, next point of factor is amount of capital. If you have small capital, then sole proprietorship is suitable. But if as an owner you can collaborate with someone, and if that person or other people, they can bring in a lot of amount of capital, then joint stock company will be suitable for you. Joint stock company is nothing but company. Then legal formalities. If you want to go through little legal formalities, then sole trade is good, because we saw that in sole proprietorship registration is not compulsory. In most of the cases, even license is not required. As such, if you want to go for the least legal formalities, you should select sole proprietorship. Partnership may not be registered, but an unregistered partnership is deprived of many advantages. Partnership also you cannot go for registration, but a registered partnership is quite advantageous than the unregistered partnership. The company is formed, carried on, and even dissolved amidst legal formalities. But if you want to go through legal formalities, then company or registered partnership form of business is good for you. Then government interference. The business activities must be carried on in the interest of the society and nation. So the modern government intervenes and interferes in the business activities. Somehow in today's world, each and every type of business organizations, they are affected by government interference. In case of sole trade and partnership, the interference is lesser. Means we cannot say that there is no interference from government. There is, but in case of sole and partnership, it is very less as compared to government or cooperative societies. Then government policy. Government, fiscal, industrial and trade policies goes on changing. So the wise and foresighted entrepreneur selects the type of business organization taking into consideration the present and the prospective government policies. Means before choosing any particular types of business organization, you have to see the government rules and all the fiscal and industrial policies or trade policies that is in your place, and according to that you have to select types of business organization. Then degree of control desired. If you want to take full control of your business, then sole proprietorship is good for you, but excessive control over the business is required because control has to be shared in case of partnership and company. But if you want other people also to take care of your business, then you can opt for partnership or company. Then duration of business enterprise. In case of temporary, ad hoc or short-term business, sole proprietorship or partnership is the most suitable organization. But for running for a long period of time, company type of business is suitable. Sorry. Now, starting a business, what are the basic factors that you have to consider before starting a business? First point is availability of raw material. Now first, before starting your business, you have to see whether the place where you are planning to start your business, it has sufficient amount of raw material available to or not. The first and the foremost requirement for starting the business is availability of the raw material to be used in the specific product being produced or manufactured by the business. If it is trading business, the articles in which the business is dealing should be easily available. Means means suppose if you are starting a trading business, then whether you will have sufficient amount of that article or the product in which you are dealing or not, that you have to see. Then transportation facilities. The business must satisfy itself about transportation facilities available for acquiring goods and sending goods. In the absence of proper transportation facilities, in the business cannot grow properly. So we know that for running a business smoothly, transportation facilities is very much important. Then communication facilities is also very much important because there should be constant task and proper link between the parties concerned. Means as a supplier as owner of your business, you should have regular communication with your supplier as well as your customers. It means that postal and telephone services must be available at the place of business. Then next is financing facilities. Finance is said to be the lifeblood of business. Now this sentence is very much important. Sometimes they used to give one sentence and they will ask you to explain for 3 or 4 marks. So finance is considered as the lifeblood of business. Means finance is nothing but money, and without money you cannot run a business. So it is very simple that if in order to start a business or to run a business, you definitely need money, and that money is nothing but finance. It is required for commencement, running and growth of business. It means that banking and financing facilities should be available for smooth running of the business. Means for business to run smoothly, or if you want to start your business, then you should see that whether is there any bank or any financial institution is available nearby or not, from where you can get loans. Then next is insurance facilities. Future is always uncertain, so there is always a risk of accident, damage, fire and even death of the businessman himself. Losses caused by this mishappening swallow the business itself. Means due to these damages also, so business suffers a lot. So in order to minimize that risk, insurance is a very good method. So you have to see whether insurance facilities is available in your place or not. Then warehousing facilities. There is a time lag between manufacture and sale of goods. Obviously the things that you are manufacturing now, you are not going to sell it on the same time exactly, so you have to store it somewhere until and unless some people or some party comes up and they want to purchase. So in that case you should have warehousing facilities. Means after manufacturing, or if you are in a trading business, after ordering from your supplier, you have to keep with yourself for some time, so there should be warehousing facility as well. Then marketing of the product. Marketing is nothing but advertisement of your product. The ultimate end of all business activities is the sale of product. There will be no profit if there is no sale. Even business cannot survive without sale. Therefore, the business must take into consideration the marketing prospects of the product. Now you have to see the place where you are trying to run your business, whether you will be able to advertise about your product or not. So these 7 were the general or the main factors that you have to keep in your mind before starting any business. But there are certain factors as well, like personal capabilities, physical construction, situational requirements, financial health, tradition, culture, and other extraordinary situations. They are important while running a business. Now there is a comparison between sole proprietorship, partnership, joint Hindu family, cooperative society, and company. Now let us see. In case of formation, sole proprietor, it is the easiest type of business organization to form. Partnership registration is optional. You can consider it as easy formation. Joint Hindu family, less legal formalities, exemption from registration, it is easy formation. Cooperative society, they have compulsory registration, they have great legal formalities as compared to previous 3. Then company registration is definitely compulsory, and it is very lengthy and expensive formation process also. Then members, only 1 owner. Then in partnership, minimum 2, banking 10, others 20. Then joint Hindu family, at least 2 persons for division of family property, then no maximum limit. Then for cooperative society, minimum 10 adults. For company, minimum 2. Minimum in private company 2, public company 7. In private company maximum 50, and in public company it is unlimited. Then in case of capital, limited finance is also sufficient. In case of partnership, limited, but more than that can be raised in sole proprietorship. Then in joint Hindu family, we know that it is ancestral property that they use for their business. Then cooperative society, capital contribution is limited because it is formed by the weaker section of the people. Then large financial resources, we know that in company they can raise capital from the general public, so it has large financial resources. Then liability, sole proprietor, he has unlimited liability. Then partnership also, they have unlimited, and all the partners, they have unlimited liability. Then for in joint Hindu family, for Karta, the liability is unlimited, but for other members it is limited. Then cooperative society and company, the liabilities are limited. Then control and management, owner, he takes all the decisions and decision making is very quick. Then partners, they take decision, and until unless all the partners consents are taken, the decision making process is not completed. Then in joint Hindu family, only Karta, he takes decision, and cooperative society, only elective representative, they take decisions, while company, separation between ownership, because owners or shareholders, they don't take any decision, all the decisions are taken by the management. Then continuity, it is very unstable. If the sole proprietor dies, then his business will also die until unless some of his family member takes up. Then in case of partnership, it is little bit stable than sole proprietor because it is constituted by partners and partners can be admitted. Then in joint Hindu family, it is very stable because if Karta dies also, then next Karta will be selected from the family. Then cooperative society, it is stable because of separate legal status, means if some members dies also, then other members, they can come and join the cooperative society. Then next is company, it is stable because of separate legal status. In company also, lots of shareholders, they can make, and if shareholders are there, they can elect board of directors for managing the business. Now this was your chapter 2. I hope you understood, and it is a lengthy chapter, but it is important. Okay, so thank you.